Good morning. Thank you for joining our webinar. I'm Ian McGlashan, and soon you'll be hearing from my colleague Lindsey Murray. This session's going to last around 30 minutes, and we'll also be posting it on our website, watershed.law. We'll send you a link to the recording and copies of the slides, but do get in touch with me or Lindsey after the session if you have any questions. Our contact details are on the final slide. So if we look on to the first slide, and that will show you the four matters that we're looking at this morning. Now, I'm going to deal with the first two, so how you can move to hybrid working from an office-based model, how you should deal with an employee who refuses to attend work because of COVID-19, and Lindsey's going to deal with whether you can make COVID-19 workplace testing compulsory and what you should do if an employee is absent because of stress at work. So let's look at the first substantive topic. So how can you move to hybrid working? Now, increasingly, businesses are asking people who worked full-time at their offices to split their time, spend part of their time at the workplace and part of their time at home. Now, interestingly, the government's flexible working task force has recommended that flexible working should be the default position of all workers post-pandemic. They're saying that should be the starting point. And so what that means is that whether it's you approaching your employees or your employees approaching you, it's an issue that you do need to understand. Now, the first consideration should be whether home working is appropriate for that particular job, whether it's appropriate for that employee, and whether it's appropriate for their home. So starting with the job and whether the job itself is suitable, you're really thinking about, are you going to encourage people in this job to work from home, merely allow it if they ask, or are you going to refuse it altogether? And if we touch on team working first, teams don't always have to be in the same location to work effectively, but usually they need to liaise and cooperate regularly through a combination of phone and email contact, but also some face-to-face meetings, and I'm going to return to that theme later. But if the roles in the team depend on each other being in the same place all of the time, home working for part of the week simply won't work. It's not going to be suitable for that job. And looking at supervision, how do you supervise people at home? Now, telephone and email can be effective with the right supervisory skills. You've got video, you've got teleconferencing, we're all used to using the various apps. But speak to your employees, speak to your managers. If either of them have concerns, but you still like to press ahead, do be careful. One of the things you should consider is starting with a trial period before you commit to a permanent arrangement, so you can see whether it actually does work, whether any fears that they might have were well-founded or not. Think about the equipment. So what technology and equipment does each job need? Will it be cost effective to install it at the employee's home? Are you going to find yourself duplicating equipment that you've already got at the office? So you'll want to balance those costs against any savings in overheads that you might make through having fewer people in your office, or possibly in time, depending on your lease, moving to a smaller, cheaper office. So it's going to be a balancing exercise. And then thinking about the employee themselves, is the employee suitable? Is this someone who's comfortable spending long periods of time on their own? Can they work just as effectively without supervision? Are they able to separate work from home life? Can they meet deadlines? Use your knowledge, use what you know about them and what they know about themselves, because you should still be speaking to them about this, to inform your decision. And also, how have they got on over the last year? You can also ask about their domestic and childcare arrangements, as long as you don't do it in a discriminatory way by, for example, asking women but not men. If you are going to ask everyone. And finally, think about their home. Is their home suitable? Speak to them about this. Home workers need a safe and appropriate space that's secure and private so that they can work effectively. They'll need a reliable internet connection and they'll need to be able to work without interruptions. So if we move on to the next slide, we look at a home working policy. Now, what should that cover? Firstly, the arrangements. What are the home working arrangements? Say what you'll provide. We mentioned equipment. What will you provide? But on the other hand, what do you expect your employee to provide? Iron those out before someone starts working at home part of the week. Also, think about the timing. Will they work set hours or will they simply work core hours with some flexibility? When do you need them to be around? When must they be contactable? And we spoke about how you'll decide whether or not a particular job is suitable for home working. Mention those conditions. What are the conditions necessary for home working? Explain those factors. Explain the factors that you'll consider in deciding whether someone should spend part of the week at home. Will they need to apply for it, or is it something that you're positively encouraging? And then think about management, think about training, think about workplace attendance. Who's going to supervise their work? What are the performance measures and objectives for you to decide whether or not they're doing what they should be doing, whether or not it's working? Remember, you're going to have a number of managers who are used to assessing the employees that report to them by their eyes and their ears, what they see and hear each day. They're going to have to adapt their management style and they're going to need your help to do it. But even someone spending part of the time working from home, think, well, are they going to have occasions where they'll have to attend the office on days where they'd normally be at home? Will they coming for training? Will they coming for meetings? If so, how often will they do it? And will they be hot desking? Think about health and safety. You've got a duty of care to your workforce and you should carry out a risk assessment. But it's two-way. Remind people that they must take reasonable care of their own health and safety too. And we've got some other matters to consider on the next slide. Go to the second one because we've already dealt with equipment and a suitable workspace. Data protection is a crucial issue. Tell people how they should be working from home, how they should store documents securely and transmit them safely. Satisfy yourself that you're taking all reasonable precautions to maintain confidentiality and liaise with your data controller. They should be part of this decision as well and part of the guidance to the staff and to the business. And also, what if it doesn't work? Or what if the circumstances change? You've got to give yourself some opportunity to terminate the arrangement. Make sure that you reserve that right to terminate the home working part of the arrangement. If you decide to do that, you'll still need to act reasonably. You'll still need to explain your decision and give notice. And that benefits you in two ways. It will allow time for you to arrange a full-time office workspace for someone, but also allow time for your employee to change their domestic arrangements. So let's move on to the next topic. How should you deal with an employee who refuses to attend work because of COVID-19? First thing is you've got to speak to them. You've got to identify the reason that they're refusing to attend work. And it may be that that's as far as you need to go. You may be able to allay their fears by showing them your risk assessment, discussing the measures that you're taking to keep them and everyone else that works for you safe. Now, different reasons are going to present different risks. If we think about disability, people who suffer from certain health conditions are at a higher risk of serious illness or death if they contract COVID-19. Discrimination arising from a disability, and that's different from direct discrimination. Discrimination arising from a disability is where an employer treats an employee unfavourably because of something arising in consequence of their disability, and they cannot show that the treatment is a proportionate means of achieving a legitimate aim. So in other words, you need a good, sound business reason for putting that disabled person at a disadvantage. So if you require them to continue travelling to and attending work, and you refuse to pay them, or you decide to dismiss them because of their absence, this could amount to discrimination. It could mean an automatically unfair dismissal or a detriment. Remember, when we're dealing with discrimination, there's no ceiling on the level of compensation. And what you do is as important as how you do it, how you arrive at the decision. So what you'll need to do is to get medical advice. Information is going to be your friend here. Obtain medical advice on the nature and extent of their condition. Ask how your decision might affect them and what adjustments you could make to minimise any risk. It's then your decision as to whether or not those adjustments you can make and whether it would be reasonable for you to make them. And of course, speak to them. See whether there's a solution that suits you both. While you're making that decision, decide whether it would be appropriate to pay them in full, particularly if you're going to have the information in a couple of weeks. It simply isn't worth the relatively minor cost saving that you might make. Then pregnancy. The government, with input from the Royal College of Obstetricians and Gynecologists, has published a guidance note aimed at pregnant employees. Do get in touch with me if you want me to send you a copy of that note. But the guidance stresses the importance of adequate risk assessments, and it also makes a couple of distinctions. It distinguishes between women with underlying health conditions and those without, as well as between women who are fewer than 28 weeks pregnant and those who are 28 weeks pregnant and beyond. And it notes that pregnant women of any gestation should not be required to continue working if this isn't supported by a risk assessment. That's crucial. But as pregnant women are identified as clinically vulnerable in the social distancing guidance, where the nature of the employee's role means that they cannot do their normal work from home, and there's no suitable alternative work available that they could do from home, you should consider suspending them on full pay if you can't sufficiently mitigate the workplace risks posed by COVID-19. The Equality and Human Rights Commission guidance suggests that requiring pregnant employers to continue to work in frontline roles could amount to indirect discrimination. And one thing to bear in mind is that the previous government advice was that pregnant women should not be vaccinated in the majority of circumstances. And that was only changed on the 23rd of April this year, so only last month. The current advice is that pregnant women should be offered vaccines at the same time as people of the same age or risk. But given that that change is so recent, it would be understandable if pregnant employees or those planning to get pregnant didn't have the vaccine and were reluctant to attend work. So do bear that in mind and be sensitive to those concerns. And if we go on to the next slide, we see the other two scenarios. And the first one is about someone with a shielding relative. Now, from the 1st of April this year, clinically extremely vulnerable people in England were advised to continue to work from home where possible. But if they can't work from home, they're no longer advised not to attend the workplace, so they can go to work. Also, clinically extremely vulnerable employees no longer eligible for statutory sick pay simply because they've been advised to shield. They need to be too ill to work to be able to get that pay. The guidance to members of a household who are not clinically vulnerable themselves but have someone in their household that is that they should continue to attend work if they're unable to work from home. The law on associative discrimination doesn't protect the relative of a shielding person from disability-related discrimination, which I mentioned earlier. But what it does do, it does protect them against direct discrimination. It does protect them from harassment. It does protect them from victimisation. And that's significant because if you do decide to grant some flexibility to someone who isn't clinically extremely vulnerable, but someone in their household is, and they're shielding, just remember to guard against any resentment from their colleagues. You might have to speak to the person, decide how much, if any, information you want to share to guard against that. Now, finally on this issue, what if there's no discrimination angle? If the employee can work from home, this may well resolve the issue, but if not, consider the current public health advice. Remember that it doesn't only change over time, it changes depending on the area of the country and the prevalence of particular variants. Examine the specific reason that the employee is concerned about attending work and whether home work is appropriate, or whether you should withhold pay in light of their refusal or take disciplinary action. If there's no discrimination angle and the public health advice is such that you could reasonably ask that employee to continue to attend work, and that's the crucial work, whether you could reasonably ask them to continue to attend work, it is possible to investigate for misconduct in terms of their refusal to follow a reasonable management instruction and their unauthorised absence. If their absence is unauthorised, then it may be that they're not entitled to pay because they're not willing to work. But even in these circumstances, do tread carefully because there is still a risk that they may bring a claim that they can't attend work because it is unsafe for them to do so. And if they've got sufficient service, that would be automatically unfair. So do take care, do take advice before acting. Now, that's all from me for the moment, but I'll put you into the hands of my colleague, Lindsey Murray.
Thanks, Ian. And good morning, everyone. So the first question that I'm going to deal with is whether you can make COVID testing compulsory in the workplace. And the government have told us that along with vaccines, regular testing is going to be necessary to help us return to some kind of normal life. So it's been encouraging businesses to provide their staff with the opportunity to be tested with these rapid lateral flow device tests. And the idea behind that is that there are asymptomatic cases that will be picked up then, and they'll be picked up quickly so that people can isolate, and that will stop the virus then from entering and spreading in the workplace. There have been about 120,000 businesses that have signed up before the deadline in April to have these free tests provided to them, and those are going to be available until the end of June. But the government have also said that individuals can test twice a week, and so they can pick up tests from pharmacies, from COVID testing centres. My primary school age children even brought 2 packs of tests home with them last night. So there's no statutory obligation on you to make testing mandatory at work, and the government guidance is that it should be voluntary, but I think it's likely to depend on what sector you work in and also the approach of your staff and unions as to whether you decide to make it compulsory to be tested. There is a legal duty to consult with employees about health and safety, and ACAS recommend consultation over workplace testing. And there'll be those union reps who consider it a breach of privacy to have to be tested, and employees who consider it to be a breach of privacy. And there'll be others who won't accept that their workplace is safe without it. And I think if there are employees who are routinely testing themselves to keep themselves and others safe, then they're likely to be really annoyed if there are people attending work with them who haven't tested at all. So if you do decide to make it mandatory, then you need to be able to show that that testing is an appropriate and proportionate action to take. And to do that, you record it in your risk assessment. So what you think are the specific workplace circumstances that necessitate testing for you, and what the particular factors are that increase the risk of transmission. I suppose if the majority of your employees are already testing voluntarily, then it might not make much of a difference to introduce mandatory testing. But I think on the basis that employers have got a duty under the health and safety legislation to devise their own systems for keeping workplaces safe, then I think mandatory testing is likely to be justifiable in the right circumstances. And so I've put on this slide the kinds of practical and legal considerations that you would take into account when you are doing your risk assessment. Firstly, it's exploring the alternatives to testing, bearing in mind that the government have said that people should be continuing to work from home wherever possible. And that guidance is remaining in place until at least the 21st of June. And then who the testing will cover. So will it be only employees, or will you require contractors, agency staff and visitors to test? And remembering that vaccinated employees should be tested in just the same way, because the vaccine hasn't been proven to be 100% effective in preventing COVID, and we still don't know yet the effect on transmission. How often will staff be tested? The government recommends twice a week, but I know employees that are frantically testing every day to make sure that they're keeping themselves and other people safe. To encourage people to test, are you going to pay them to self-isolate if they test positive? Where will the tests be carried out? If they're not going to do them at home, if they're going to do them at work, what about those people who rely on public transport to get to work? How are you going to make sure that they can get home safely if they test positive? How will you use that test result information? So it's about updating privacy policies and data protection impact assessments to enable you to process that health and safety data. And you've also got an obligation as an employer to report the testing results to Public Health England. And I've included at the end of the slide just a reminder that employers mustn't knowingly allow an employee to come into work if they've been told to self-isolate, because there's actually a criminal liability that could attach to both the individual and their employer if they came into work in those circumstances. So if you do decide to make testing mandatory and an employee refuses, what can you do about that? Well, first, I think it's about taking the time to understand why the employee is refusing to take the test. It might just be that they need reassuring about the testing process. If they've never experienced it before, they might think that it's something that's painful, or they might be worried about their privacy when they take the test and what will happen to them, what the consequences will be for their life if they do test positive, what impact that's going to have on their daily living. If an employee's got a valid medical reason for refusing the test, then I think taking disciplinary action in those circumstances could amount to disability discrimination. But I think ultimately, if an employee can't do their job from home and it's reasonable to ask them to test, then you ought to be able to discipline them for failing to follow a reasonable management instruction. Sending an employee home on nil pay for refusing to take a test, though, could give rise to a claim for unlawful deduction from wages, unless you've got a clause in your contract that enables you to suspend employees without pay. And those clauses are really rare in employment contracts. But I think what a tribunal will be looking at when they're considering whether dismissal for refusing a test was fair is how the testing regime was introduced in the first place. So they'll want to see employees and representatives of trade unions having been properly consulted about the proposals, and if they've made any recommendations for change, that those recommendations have been considered, that any suggestions have been taken on board. And they'll want to see whether testing was introduced as part of a wider set of policy changes to create COVID secure working conditions. And I think if you've included a contract term to make it contractual for new starters to test, then I think it's those kind of measures that would give you stronger grounds then to be able to start disciplinary proceedings against people for refusing to test. So the next thing that I wanted to talk to you about is stress at work. Lots of employees are liable to suffer stress and anxiety and loss of confidence and low mood at some point in their careers. But I think this is a particular risk at the moment with people coming back to work from furlough, and also where staff reductions mean that employees are being asked to take on work that they wouldn't ordinarily do. And I think for people to struggle with that kind of change is part of the normal human experience. But it's generally only when an employee tells you that you're struggling and you fail to do anything about it that liability for that stress can attach to you then as an employer. And I've set out on this slide some of the types of claims that an employee complaining about work-related stress might be able to bring. So the first one there is personal injury. And that's generally when an employer has been negligent and they've breached some kind of health and safety legislation, or it might be restriction on working hours, for example. The next one is where an employee suffering from stress could argue that the employer's breached the implied duty that there is to take care of employees' health and safety at work. And I think that might be the case if their workload was really excessive and they resigned in response to that and could claim constructive dismissal. I think an employee who's sacked whilst being signed off sick with stress might be able to bring a claim for unfair dismissal. And where anxiety and depression result from work-related stress, then it might mean that they've got a mental impairment that meets the definition of disability under the Equality Act. And they'd then be protected from disability discrimination and also from harassment. But there's also a criminal liability that can attach to harassment, and that's under the Protection from Harassment Act. And that prohibits a repeated course of conduct that amounts to harassment. And there's a really rare employment case on this where an employee was wrapped in cling film and locked in cupboards and they got to the point where they were literally crying under their desk, and it was criminal liability that was found to have attached to that. So on the next slide, what do you do when someone tells you that they're suffering with stress at work? And I think it's easy to think, well, it's work that's stressing that person out, so the last thing that I should be doing is contacting them from work. But this opposite is actually true. The sooner that you engage with that person, find out what the cause of that stress is, and show them that you're prepared to take steps to deal with it, the more likely they are to return to the workplace quickly. It's recognised that stress is actually a positive motivating factor in work. And so the problem really only comes when an employee's perception of the demand that's been placed on them is that it's too much, that it's excessive. So it's about what steps you can take to alter that person's perception. And all that the law requires you to do is to provide appropriate support and monitoring for that person. So it's about establishing what it is that the individual thinks is too demanding of them, that they can't cope with it. And remember that everyone is different and everyone's tolerance to pressure is completely different. What you're trying to find out is what steps you can take that are going to make a difference to them, to make them feel like they're back in control of their work. And so the secret that I wanted to share with you is Appendix 6 of a Health and Safety Executive booklet on stress. And I've included the link in the slides, and these slides will be made available to you after the session. I think what's reassuring about this Appendix 6 and the suggestions that are in there is that it makes providing support to employees look surprisingly simple, and more simple than you would imagine. So if we're going to have a look at what those are, so we've said that the first step is to find out what the employee thinks they're struggling with, and that should then be recorded in a risk assessment. And then you go to Appendix 6 and you find out which category of the health and safety executive's management standards it falls into. So basically the health and safety executive have identified 6 different main causes of stress. And then they've suggested the types of things that you can do to address each of those causes. And what you're trying to achieve, remember, is for employees to feel like they're able to cope with the demands of their role. And employers who offer a confidential advice service with counselling or therapy services, are less likely to be found in breach of the duty to take care of their employees. But there are other things that you can do that make use of the existing tools that you have, the tools that already exist for managing workload, and those should help you minimize the risk from stress. So that might, in the case of HR professionals, involve the case trackers. It might involve project plans, anything that enables you to predict future workload. And then it's about using those things then to make changes. So it might be changing the case types that are assigned to someone, reducing the number of cases that someone has, amending timescales for completions of projects, dividing up the responsibilities differently so that employees are given things that they feel that they're able to do. You might assign a buddy to someone or a mentor, someone that's a first point of contact whenever they feel like they're starting to struggle. And that can also be really useful from a kind of on-the-job training perspective. It gives someone else the opportunity to job shadow. You could arrange for there to be kind of extra help or for duties to be redistributed just for a little bit while employees get themselves back on track. You could consider transferring that employee just to do the type of work that they feel that they're able to do. But how reasonable any of those steps are, of course, depends on the size of your business and the success of that business and any of the other demands that are placed upon it from customers and even from other employees. So I appreciate that there's a lot to consider, but it gives you a starting point and it gives you some suggestions for things to put in place. So that's what I wanted to share with you, particularly on stress at work. I hope you found the session useful, and please put in the chat if there are topics that you'd like us to cover in future sessions. Mine and Ian's contact details are there on the slide, so please do contact us if you need us. And in the meantime, I'll continue homeworking in Bolton, which is big in the news at the moment for all the very, very wrong reasons. And I'll wish you all well. Take care, and thank you so much for joining us today.